Welcome, everyone. Just letting folks in from the waiting room. Give us a moment while we do that. All right, welcome. So we're letting folks in from the waiting room. May just be a couple of moments here while we get started. Welcome to the webinar today. This is a webinar, New Year, New You, with Michelle Dellino, and we're going to be talking about everything you need to know about divorce and how to make take the steps that you need to do to make a move and things you just might be thinking about in the new year. I'm going to turn it over to Michelle in a moment to introduce herself and get started. But first, I'm just going to introduce myself and talk a little bit about the format. My name is Melissa Rosenberg, and I'm a therapist here in Seattle. I operate a private practice called Better You, and one of my specialty areas is working with clients who are in different phases of the divorce and separation process. So I do work with clients in the early stages who are trying to contemplate whether or not separation or divorce is their right move forward, and kind of unpacking those emotions that are involved. I work with clients who are in difficult or high conflict divorce situations, and navigating that process, and also on the other end with clients who are trying to build their next chapter forward. I'm a couples therapist and also an individual therapist, but today I'm here as a moderator for this webinar. And so I'm here to work with you and Michelle and get questions asked and answered and make sure that everyone gets the information that they need today. So Michelle's going to be delivering a lot of information. And while she's doing that, if you have questions that come up, I want to invite you to ask them. And there's a couple ways that you can do that. There is a chat at the bottom of the screen, and I recommend doing it that way, just sending your question in the chat. It'll come straight to me, and I can pitch it to Michelle. Keep in mind that they can't be too fact specific of questions, nothing too, overly specific about your situation or overly detailed about your situation. More general questions are what we can answer today. But feel free to send those to me in the chat. There's also a Q&A on the webinar, I believe, screen. And so if you want to submit a question that way, you can. Just note that you'll need to make yourself an anonymous attendee. Otherwise, your name will show up with your question. So that's up to you. You can submit the questions either way. I'll be looking for them and I'll ask them, and we'll get through as many as we can today. So we'll be here until just about 1 o'clock and try to give as much information as we can. And with that, I will turn it over to Michelle.
Hi, thanks for being here today. I'm Michelle Dellino. I'm the owner and founding attorney of Dellino Family Law Group. We are a family law firm with offices in Seattle and Bellevue. We help clients actually all over Washington State handle their family law issues. So that might be a divorce, it might be a committed intimate relationship, it might be a parenting plan modification, a relocation, whatever it is, we've probably seen it before. I like to tell people, your crazy is kind of our normal. So there's really nothing that we haven't encountered. So today we are here to talk about New Year. Like New Year, New You. What do you do if you're thinking about divorce or separation? How do you even get started? What are the basics? It's very overwhelming. So what I'm going to do is I'm going to talk about some basics, some things for you to consider. Some of you watching today or some of you watching later on a video replay have probably already thought about some of these things. Some of them might be things you haven't thought about. So it's going to be a little bit of things you can do, things you can think about, and just some basics on Washington divorce and family law in general. But the first thing I want to talk about is, since it's a new year, a lot of people between January and March particularly think about, I need to make a change. I don't want to go through another holiday like that. I want to change my situation. I'm super unhappy. What I would encourage you to do before you do anything, if you are not working with a therapist, I would encourage you to get one. Maybe your work, and if you think you can't, you might want to check. Your work might have employee assistance. They might have the ability to give you access to some free sessions. If you have insurance, that might be a thing. If you're able to private pay, that might be a thing. But like Melissa talked about, she has a specialty in relationship transitions. There's her and there's other therapists like her that are able to step in and help you. It's going to help you in your case in a couple of ways. One, it's going to reduce your legal costs, because people are like, divorce is so expensive. And yes, it is, but it's even more expensive if you're trying to use your attorney basically as a therapist. Number one, we need to know what's going on with you, and that's important, but we're not qualified for that. Like, I'm not qualified to help you deal with the emotions. I'm not qualified to help you manage, when is the right time for you. I can tell you the legal things. I'm going to talk about that today. And it doesn't mean I don't want to hear about it, but really, if you don't have a therapist, you're doing yourself a disservice as far as stress management and also as far as from a financial perspective. And to take it one step further, if you have children and there's a custody issue, it actually is a good thing for you if you have a therapist. It shows the court that you're taking your own mental health seriously, so you can show up for your children in a healthy way. So those are just a few thoughts that I hope are helpful as we get started. So new year, new you, let's talk about it. Okay, so first thing you might want to do, and this is not just because I'll say this, I'm not because I'm an attorney. I'm not telling you this so you come to me. I don't really care what attorney you go to, but you need to talk to an attorney. Divorce is the most complicated legal contract that you're ever going to need to undo. A marriage is the legal contract, and a divorce is going to undo that. Your legal rights, financial obligations, parenting rights are all intertwined with another person. So you need some help in undoing that. Can you do a divorce without an attorney? Yes, you can. But in the same way that I would not try to perform surgery on myself, or I don't do my own taxes, even though I know a lot about taxes, I would recommend that you get help from a professional that knows and can give you a detailed analysis of your situation, what your areas of risk are, what's a reasonable settlement for you, and what you can expect. Because if you don't know, you don't know. I'll very often have people come to me who they do a DIY or they try to just mediate it with the other party, and the other party's like, oh, let's agree on dividing everything equally and we're going to do this or that. And then they come to an attorney because the attorney needs to draft it for you and they say, is this a good deal? And I'll have to say, well, no, that's like the worst possible situation you ever could have gotten. But you didn't know that because you didn't ask anybody. And now you're asking somebody, and now it's late in the game and you kind of have to redo things. So anyway, get advice up front. I can't stress that enough. Talk to 2 or 3 attorneys. Find somebody that's a good fit for you. So that is something very, very important for you. Okay, where do you start? Understanding some basics about Washington divorce. So first of all, Washington is a no-fault divorce state. You might hear that, but what does that mean? It means you don't need to prove wrongdoing, only that the marriage is broken. And it's broken if one person says it's broken. Sometimes I'll have clients that come to me and they'll say, I don't want a divorce. It's nobody's fault. I don't want to. Can I say I don't want it? No, if somebody wants to get a divorce, as much as you might not want it, it's going to happen. Nobody has to prove fault. The other thing that that means for you is if someone cheats on you, commits domestic violence, does any of those things, fault is not a reason to apportion more money to somebody. It can be a reason, like if there's a restriction with parenting time, if it's not safe for your kids, but because somebody treated you poorly in a divorce, the Washington court is not going to see that as a reason to give someone more money. So that's very, very important to know. We are a no-fault state. What's the timeline? Well, the soonest you can get divorced in Washington is 90 days from the time that you file and serve the other party, or that you're served. But is your divorce can be over in 90 days? No. Hardly ever, unless everything is all agreed and you don't have anything and there's nothing to talk about. Even a divorce that's like cooperative and everybody's just exchanging information, figuring things out, and really trying to be amicable, even a divorce like that's going to take longer. So how long is a divorce going to take? Well, it depends, which is maybe not the answer that you want, but it's an honest answer. If you're in King County, there's a case schedule that's generated that gives a bunch of benchmarks in your case, and it gives you a trial date a year later. Now, 10% of family law cases go to trial, actually even less than that. So 9 out of 10 people are never going to end up at that trial date. They're going to resolve it beforehand, either on their own or in a mediation. But how long does that take? The average divorce case that has any kind of issues at all, has any children, property, anything to work out, average time, I would say, is 9 months to a year. Could it be less? Yes, absolutely. Some divorces resolve in 6 months or 3 months. Could it be longer? Yeah, some will go on for 2 or 3 years. So it really depends on your individual situation. But I like to talk about my friend Rafe Palmer, who is a divorce attorney in Chicago. He has a best-selling book that's called I Just Want This Done. And that's how everybody feels. So if you feel that way, you're not alone. I just want this done. But a divorce is a marathon. It's absolutely not a sprint. You might have a few sprints in between there, a sprint towards temporary orders, a sprint with getting discovery done, a sprint to get ready for mediation. But it's all part of a big marathon. So prepare yourself for understanding that when you start to think about divorce in Washington. Other basics to know. Washington follows community property laws. So this is a community property state. I'm going to talk for a minute about what that means. Community property, what is it? It is any asset or any debt that's acquired during the marriage is presumed to be community. Now, there are things that don't count, things that are income that might be earned from other separate property that you own beforehand, gifts to you during the marriage. There are a variety of things that don't count, but the presumption is any assets, any debts awarded during the marriage or earned during the marriage are community. So then once you know what community property is, what do you do with it? What does that mean? Community property means both parties have an interest in it, regardless of whose name is on title. So if you work during a marriage for 10 years and you put money into a 401k and it's only in your name, it doesn't matter. Your spouse still has a community interest in it. How is it divided? Many people think community property is divided 50-50 equally. No, that is not the case. We are not a 50-50 state. There are states where community property is divided 50-50 no matter what. What that means is a lot less to fight about. In Washington, we are what's called a just and equitable state. And if you've ever heard me talk about this before, this is going to be redundant for you, but it's the best way I know how to explain it. What does just and equitable mean? It is supposed to mean what is fair. Okay, well, the word fair, if you're going into a divorce, take that out of your vocabulary because I like to tell people there's only two fairs. I used to say one, but there's two now. There's two. One is if you ride the light rail or the bus or you an Orca card to pay for the fare. You're paying a fare. Fair, fine. Everybody knows what that means. The second is if you go to the Puyallup Fair every year or you go to the Evergreen State Fair. Those are like the main fairs. That's a fair. That's what it means. It does not mean that you and your spouse are going to agree on what's fair in a divorce. Your perception and his or her perception is going to be totally different. So take fair. I don't want to hear if you're working with us or don't tell your attorney that's not fair. No one's going to care and it means nothing. So if fair is out of the equation, how do you decide what's just and equitable? Two main ways. One, what is the length of your marriage? These are objective measures, and these are things you need to know. How long are you married? Is it a short-term marriage, a midterm marriage, or a long-term marriage? And we can talk more about what that means later. How long? The court wants to know because that determines number of things. And number two, what is the financial situation of the parties at the time of the divorce? Are you both working? Do you make the same amount of money? Has someone been staying home? Like, what's the situation? How much do you make? And how long are you married? That is going to help determine what is a just and equitable distribution. For example, short-term marriages, 5 years or less, party's going to go back to the situation that they came in. Nobody's relied on the marriage very long. That might be a 50-50 division. Midterm marriages, it might be a 60-40 division. It might be a 70-30. It might be a 55-45. A lot more information is required. It is not an even 50-50 guarantee ever. So that is something for you to know and to think about. And then the third thing is, can you even file for divorce in Washington? Are you a resident in the state of Washington? Did you just move here? Do you have kids? Did they just move here? How long have they been here? You need to have children in Washington for 6 months. They need to reside here for 6 months for Washington to have jurisdiction over them. You, if you're a resident in Washington, you can file for divorce here. What does jurisdiction mean? I'm going to talk about that, and then I'm going to pause after these initial basics. Jurisdiction means the authority of a Washington court to enter an order that you have to follow. So the court, if you're not a resident of Washington and have no significant ties to Washington, can't enter an order and make you do something. So they can't also make an order about where your kids should live if they haven't been here for 6 months, unless there are other exceptions. So any number of things. Do you have the right to file a case here? If you do, great. But sometimes that's not so simple. Sometimes people might have just moved here. Sometimes people might be moving to somewhere else. So those are important things to think about. What's going to happen? Let's just to recap. Community property is going to be the law of how things are divided. We're a no-fault state. Fault doesn't matter, doesn't have to be proven. Residency, you have to reside here, or your kids have to be here for 6 months. So those are some very initial basics to get us started. Melissa, are there any questions you'd like me to answer before I move on to the next section?
Yeah, there's a couple of questions that are coming up here. One person saying that their opposing party is a high conflict person, asking that all of her socials and professional accounts and associated emails, all of that information in the interrogatory. Wondering if she can say no to that. And she's concerned that, the families are all engineers and they're going to hack into her account and do things to tarnish her. Just, really concerned about having to give up so much personal.
Yeah, really, you're asking about discovery. That's what you're asking about. And I'm not going to give you a specific answer on what is not discoverable in your case without looking at your case. You should talk to your attorney about that. But I'm going to tell you this. Discovery. In your case, and what you're dealing with now. I'll tell you generally, do you have to provide social media profiles and information? Generally, you do, yes. And that's unfortunate. And I totally get what you're saying. And I get why that feels vulnerable, and there might be an exception that you could try to protect it, but generally that's going to be required. Here's the thing to know. Okay, emails, the other thing too. Emails are generally discoverable as well, as long as they're relevant. If they're with you and your attorney or something that's privileged or therapist or medical provider, then no. But a lot of other times, yes, depends on if they're how discoverable they are and what the situation is. Here's the general thing to know. Okay. Discovery. If anyone's like, what the heck's discovery? Well, then you're not very far along in your case yet, and lucky for you. But it's good for you to know. And not every case is going to have what we call formal discovery, but many cases are. Discovery is the process by which one party discovers information from the other, like it sounds like. Sometimes you can do what's called informal discovery, where you agree to exchange certain financials or information with the other party. But a lot of the time, that's not what's going to happen. And what this viewer is describing is a very common situation where you've been served with what are called interrogatories and requests for production, where you have to answer different statements under oath and you have to provide documents. There are legal bases for objecting to some of those requests. Whether you have a basis to object is going to depend on the specifics of your situation and what's being asked for and what the context is and the history of your case. So that's why I can't tell you for sure what is going to happen or not in your case. But generally, discovery is what the courts call a broad tool. So if something may lead to admissible evidence, it can be discovered, which means it's pretty broad. It's not a very narrow scope. So a lot of the time questions can be asked that otherwise might not be admissible in court later, but they have the right to try and discover to determine what might be admissible. So it's a pretty broad brush. So that's one thing to let you know. I'll move on to another question because I'm sure there are others, but hopefully that helps.
Yes, thank you. Okay, another person's asking kind of how to handle things if the other parent doesn't really spend quality time with the child, lies about things like I'll take him to do this, but doesn't really do it. Maybe it's a good, segue to talking about parenting time and what,
Yeah.
what you can and can't do in those situations.
Yeah. And I don't know if you've filed for divorce yet or if you're just thinking about it, but here's the thing to know. Okay. So anytime a parenting plan is created, anytime you have children, a parenting plan is going to have to be created in your divorce. And this is something else I was going to talk about, so we'll talk about it now. So if you have a parenting plan and it's in place, or it's going to be in place, this is how that would work. Parenting plan is always going to look at what's in the best interest of the child, right? And it's going to give both parents residential time, unless it's a real extreme situation where one parent has restrictions and doesn't have time with the child. But most of the time, both parents have time. So on your time, you're going to do what you want to do with the kids. And you don't have to account to the other parent for what you're doing, where you're taking them, unless it's something that you have joint decision making over, like a doctor's appointment or extracurricular activities or something. But you don't have to account for it. So if you're worried about like this parent is not spending quality time with the kids, well, if it's their time, you don't get to determine what's quality time. A lot of times people will say, oh, they're not taking them to this, they're not doing that. Well, if it's agreed upon activity and they have to, that's one thing. But otherwise, you don't get to dictate how they spend their time and they don't get to dictate how you do it. So basically, your parenting styles can be very, very different. And this is a really hard thing post-divorce. I think Melissa probably deals with a lot of her clients too. Like, you know, you want to be like, well, they're taking them out to McDonald's. We weren't doing that before. They're letting them stay up super late. I wasn't doing that before. And as long as it's not like a safety concern, there's really not a lot you can do. You have to honor their parenting style and not get involved. So that might not be what you want to hear, but this is something that comes up a lot and it's a huge adjustment. So.
Yeah, it comes up a lot. And it comes up a
Yeah.
lot with a lot of my clients.
Yeah.
I think the adjustment to dealing with a parenting style, or sometimes having your kids come home to you and complain about what's happening at the other house. That's, oh, your dad didn't take me to this. It's so boring there. I just get to sit around and do nothing. I mean, this comes up quite a bit. And that's really hard to hear, and so just to validate, that's really, really challenging. But I think what Michelle's saying is that there's very little that you can do unless it's a safety concern, or unless there's an agreed upon activity that, if everybody's agreed this person's involved in this extracurricular activity or sport, then maybe. But if it's just a matter of kind of getting out and doing things, I think it's really challenging because, you're really having to adjust to a loss of control. Sometimes if you're the more involved parent, then maybe you were kind of setting the vibe for the home. and now you're having to kind of share time with somebody who has a different style and a different vibe in their home. And it might not be what you feel is appropriate for parenting or the right way to parent at all. And that is hard, just really, really hard. I cannot tell you how many clients have to work through this in therapy and really understand, and I would say grieve the loss of parenting and the way that they wanted to parent.
Yeah.
It's a form of grief, really. And so we work with a lot of clients in this process, just trying to kind of understand and navigate how challenging that is. But can we talk a little bit about, Michelle, too? What about safety? What if, there's concern about what the other parent is doing, leaving them alone unattended if they're too young or those
Sure. Let me
things.
talk
And also
about
if
that.
there is an extracurricular, what if they've agreed on something and they're not getting to soccer practice, even though everyone's on board
Sure.
with them being, yeah.
Yeah, we could talk about that. So, okay. First of all, it's a pretty high bar to say something's a safety concern because a lot of the time it just might come down to you think it's a safety concern, you don't like it, but is a child really in danger? What's age appropriate? So, in a situation where some people I've had it come up where, well, dad lets the kids walk home from school and they're not old enough, and that's not safe. Something could happen. That's probably not going to fly unless it's like obviously really dangerous or something has happened. And I don't like to say to people that something has to happen to make it a safety concern, but sometimes it does. If you have a child, that's exposed to, I talked about this the other day, actually, on another video I did somewhere, where if you have a child and do I have to send a lot, this comes up a lot, like, do I have to send my child if I think it's unsafe? No, you don't. But you better be sure that it's really unsafe. So if you're like, oh, there's drinking and drugs going on at the other parent's home, I don't want to send my child. Number one, how do you know that? You're not there. How do you have personal knowledge of it? If not, and you just think that, that's probably not enough. But if you really have a reasonable belief and you can support it, then yeah, of course, be a parent. Don't send your kid to a dangerous environment like that where there's nobody to watch them or someone is under the influence or they're driving under the influence. Here's an example. Parent comes to an exchange and you smell alcohol on their breath. You're not going to put your child in the car. And then you can say, I observed that. I said no. Okay. But here's the second part of that. If you really think something is unsafe and your parenting plan allows that other parent time, you better be ready to go to court and try to modify your parenting plan or get an immediate restraining order if you think it's a real immediate problem. And you're going to have to support that. And it can't just be because I think that or somebody told me that. So is it actually dangerous? Only you know. I could go through a million different scenarios that are or are not dangerous. But the bottom line is be ready to support why you think that, because that's the first thing the court's going to want to know. And the other parent's going to say, a very common thing will be, well, we've been divorced for 5 years. He hasn't seen me, at all except for an exchange. He doesn't know anybody I know. How does he know what's going on at my house? So that's one thing to think about. Maybe your kid is telling you something. Maybe your kid is coming home with bruises. Maybe if something like that is happening, well, then you have something to look at. My kid has physical injuries after being at the parent's house. I'm not going to send them back. Things like that. But if it's just difference in judgment, oh, so-and-so let someone walk home from school. So-and-so let someone be at the library alone after school and didn't pick them up for, a half an hour. That's probably not going to cut it. So things like that to think about are super important. I know that's difficult and it's not what everybody wants to hear, but I like to be objective with you and realistic with you about how a court is going to see things, because how a court is going to see things is very often different than how a parent is going to see things, and it's a tough situation. Before we answer another question, I do want to make sure I get this out there because we're talking about basics, and if you're thinking about starting the process, you need to know financials. I want to skip to that for a minute. What are the financial documents you should get together? This will help you save time and money in getting your case started. Your attorney, or if you're representing yourself, the court eventually is going to need your financials. You're going to have to disclose them. So what's a good set of financials to get you started? I like to say a year, but a minimum of 6 months of statements in every account that you have a financial interest in. So checking, savings, investment accounts, retirement accounts, also your debt accounts, your mortgage, your car loan, your credit cards, 6 months of every account that you have a financial interest in. That can take a lot of time, but you can download those statements. What I recommend Set up a folder, say Bank of America, the last four digits of the account, Bank of America 1234, and then put, January, February, March, April, May, put them all in that one folder. Do the same thing for every account that you have. Organize them like that. It will save you time and money, and you won't be paying someone to do it for you later, and they're going to be definitely necessary. So I would say err on the side of a year of statements. 6 months, if that's what you have, that's totally fine too. 6 months of pay stubs is a minimum. Also prefer a year. Complete pay stubs. 2 years of tax returns, including W-2s, showing your financial income for the past 2 years, and your tax returns. Business financials, if you have them, same thing there. 2 years of business tax returns and 6 months minimum of all statements. Here's the other thing to know. If you're the party that doesn't have the records and you don't have access to it, that's totally fine. Just do what you do have. And then the rest we can work out later. But yeah, debt records, credit cards, personal loans, mortgages, all of those statements as well. Property. Make an inventory of the property that you have, whether that is real estate or cars, get those things together. And then the other thing to know about too, when you think about your financials is this, you're going to have to do a financial declaration probably at some point in your case. So start to think about what your monthly expenses are. You'll want to think, how much am I spending right now? And how much am I going to be anticipating spending post-divorce? So the way it typically works is you'll have to do a declaration stating what your expenses are, and then you have to have the financial documentation to support it. So it's a good time if you don't know how much you're paying for your cell phone or for internet to take a look at that in your statements. So I hope that helps. I'll take another question.
Great, thank you. All right, let's see. This person's asking if they're saying their spouse filed for divorce on January 10th, that's 20 days ago, but has not told them or had them served yet by a third party. What do you do to prepare and be legally advised before signing any legal documents?
Well, get an attorney. Yeah. And here's the thing, if they haven't served you, if they filed a case, you don't have actual notice of that case or have to do anything until they actually either have a third party serve you with the paperwork or until you agree to sign what's called an acceptance of service. Sometimes and this is good for you to know, everybody watching, if an attorney sends you the paperwork or the other party hands you the paperwork and there's like what's called an acceptance of service in there, it means you're accepting that you receive the documents. You're not agreeing to anything in the documents. And typically initial documents don't say much anyway, because again, the discovery has to happen and you don't know what's going to happen in the case. It usually just says, I'm filing for divorce and this is what I think. But you do have to file a response. But anyway, if you sign an acceptance of service, so someone doesn't have to send a process server out, that's one thing, but be very sure that you're just accepting the paperwork and not agreeing to anything. If you haven't been served with the paperwork and haven't signed an acceptance of service, then you don't have actual notice of the case. So when they do serve you, then you're going to want to work with somebody on a response to the petition. They'll serve you with a petition for divorce, and it'll say, I claim this, 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 and this. It won't give a lot of details usually, but it'll say one party should pay spousal support, one party should pay child support, somebody should pay my attorney's fees. It'll say very basic things. It'll say when you got married, when you separated, all those things. And you're going to basically either agree, disagree, or give more information. How you answer those questions is extremely important because you could be locking yourself into a position without realizing it that you shouldn't be taking. So you really want to consult with somebody before you file a response to a petition for divorce or before you bring your own. Because if you're going to bring your own and you think I can print this out and just say this, this, or this, you could be foreclosing claims that you need to make later. I've had many people come to us later that filed a response or filed a petition, and it keeps them from getting help later. Then you have to seek to amend it, and then you have to go to court, and you have to do a number of things, and you might not be able to. I had somebody not ask for spousal support when they should have because they didn't think they would need it. Then they ended up really needing it, and they went to court to try to amend the petition. We were actually on the other side. We said, no, they shouldn't be able to because they waited till late in the game, and the court said, no, too bad, too late. Should have pled that in the first place. So you really need to be careful about moving and pleading for divorce or responding to a petition. But as far as getting served, if you get served and you're just served with it and nothing happens except for you have to respond. And if you sign an acceptance of service, that's just saying I accepted the paperwork, not that I agree to what's in there. So that's a very important thing to know. I did want to add on that we talked about basics on parenting plans and having a plan that's in the best interest of the child. I just want to say what a parenting plan is, just because I didn't say that, just for anybody that might be watching and what to know. So a parenting plan is going to determine what we call in Washington a residential schedule. We don't call them custody orders. We don't call it custodial time. We call it residential. It's just what we do. It's a friendlier term. So basically there'll be a determination of where your kids should live when, what vacation schedules look like for school breaks, summer breaks, whether the schedule during the summer should be the same as the school year, what holiday schedules look like, what decision making is, because when you're married, you make decisions together, or sometimes one party makes them about where your child's going to go to school, extracurricular activities, non-emergency medical decisions, orthodontia, physical therapy. You're going to have a decision-making process for that and know who's going to make those decisions. All of that comes within a parenting plan. So that's what the parenting plan is. Obviously, it's super important. There are four main things that you need to know that are going to be decided in a divorce with children. One, division of debts and assets. What's the community property? What's the separate property? How does it get divided? Two, is there going to be spousal maintenance? Will one party pay spousal support to the other? Yes or no? If so, what will it be? Three, the parenting plan that I just talked about, an order determining where your kids live, who makes decisions, what's visitation, anything else we need to know, what's transportation during residential time, all of that. And then four, child support. If you don't have children, you obviously won't decide the parenting plan and child support. You will decide whether there's maintenance and how community property is divided. So the other thing to know, child support. Washington actually uses what we call a statutory formula to determine what support should be. Child support actually is usually the easiest thing to work out in a divorce because it's on the numbers of the income of the parties. Sometimes somebody's income is imputed if they're voluntarily underemployed or haven't been working, but that's actually a fairly straightforward calculation. There can be some deviations to a standard calculation, but child support in general is probably the least stressful thing that you're going to have to deal with, and a lot of people don't know that. So anyway, those are some things for you to think about. I can take another one before I move on.
Yes. Okay, so this person is asking, they're saying kind of about date of separation. They're talking about how they moved out 2 years ago, but did sort of sleep over in the house for a while and then was back in the house for another 6 months. When does separation start? How do you decide in some of those gray area cases? And do divorce papers have anything to do with that actual date of separation?
Huge. Yes, huge. When I told you to be careful about what you put in your petition and your response, that is when you first address date of separation. You could lock yourself into a date that's not accurate, or you could agree to a date without realizing it. The date of separation matters. Why does it matter? I talked about community property earlier. Community property stops on the date of separation. So the most common way to determine date of separation is the date that the divorce is filed, but that's not always really the date. So you've been living together and one person decides and kind of surprises the other person and files for divorce, that's probably the date of separation is the date of the divorce petition. But many other cases, it's much earlier. I had a case I like to think about sometimes where they'd been separated for about 15 years before anybody filed for divorce. So then we had to go back and actually figure out what, the date of separation, the community had stopped 15 years earlier. So there was all this separate assets and income after that. So it was kind of a mess. But anyway, long story short, how do you determine date of separation? Somebody moves out. Okay. In your situation, if you move back in, or you're still working on the marriage, even if you're living separately, maybe you're in couples counseling trying to work it out, or maybe you're going on dates because this is a trial separation. If you move back in the house, it sounds like you pretty much reconciled, and then the date of separation is probably, and again, I don't know your circumstances, it's probably when you left the second time or when somebody filed for divorce the second time. It is typically when the marriage is defunct. When one party tells the other it's over and we're done, and they don't go back on that, when there's no more efforts to reconcile, you can have a date of separation and be in the same house. Somebody could move out of the marital room and move downstairs. That could be a date of separation. So there's any number of ways. It's a very case-specific and fact-specific thing, but it's very important. Often in cases too, I have had numerous cases where this comes up. One party's trying to say it's one date because they got a big bonus or they got restricted stock units after that date. The other party is saying it's later because they're like, no, we were working on it, so all this should be up for division. But once that date of separation is determined, everything after that is your own separate property. If you go to work and you earn some money, that's going to be yours, as opposed to it being community that's up for division. So you can see why someone might fight about the date of separation. That's a great question. Thank you for asking. I can answer one more, and then I'm going to talk about temporary orders.
Okay, let's see, we're talking about, let's see, trying to make it a more general question. Somebody, a spouse stayed home for a few years, but prior to that worked a ton, has much more money than this other person. Anyways, long story short, I think we're wondering about what does the court look like as far as status quo, or when making decisions about financial division or spousal maintenance. Is it just the last 6 months or the last couple of years, or do they look at the larger picture?
They look at the larger picture, but actually all that really matters. I mean, the story of your marriage matters. Like, is my income, they're going to look at what, okay, let's say people are getting divorced, 15-year marriage. Income, both parties are working, but one party makes 3 times as much as the other. Why? Is it because one party stayed home and took care of the kids and then went back to the workforce later? Is it because one party supported the other while they were in school, getting a more professional job? Like, what's the story, right? Like, some of that does matter, but what really matters is what your situation at the time of divorce and what your income potential is and how long you're married. If you're in a short-term marriage, I touched on this earlier, it's backward looking. Nobody was like relying on the marriage long enough. So basically, you've got to go back to the position you came in, and that's not going to be necessary for anybody to feel like they need to be made whole or they need to have some rehabilitative time. Very, very rarely, maybe on a temporary basis only. Midterm marriages can range anywhere from 6 years up to 24 years. And in those marriages, the longer that it is into a midterm marriage, the longer there's going to be a principle of exiting the marriage on equal footing, especially if there's kids, exiting the marriage on equal footing because you relied on the marriage for a little while. You made decisions in order to do equity, what is supposedly fair, really what's equitable is what we're going to use as a term. The court's going to look at what happened in your marriage and why, and like I said, did you stay home? Did you take a different job to move because somebody moved for promotion and you went with them? Like, what's the circumstances and what's your income potential now? If you are exiting the marriage on equal footing, you might be getting spousal maintenance. Spousal maintenance is what Washington courts call a flexible tool to do equity. So we also don't have a formula for it, but we have some basic guidelines. Every 3 or 4 years of marriage equals 1 year of post-divorce maintenance is a pretty typical rule of thumb. And that is only if there's a discrepancy between incomes. Because if there's no discrepancy between incomes really, or it's very minimal, there's no reason to pay maintenance. But if you're married 12 years, you're going to probably get 3 or 4 years of maintenance if you're making a lot less than the other party, and yet if the other party has the actual ability to pay you too. So there are a lot of other factors that come into play, but spousal maintenance is a flexible tool. It's often used in conjunction with determining the property division. Washington is very much what I would call a choose your own adventure divorce state. You can structure a deal that maybe doesn't pay you maintenance, but pays you more in a lump sum up front out of the property division. Or if you need to qualify for a home loan and you want those consistent payments, or there's not enough up front to lump sum you might get monthly payments. There's different ways that you can structure your settlement. So anyway, I hope that's a little bit helpful.
Yeah. Yeah. And maybe you could talk about for committed intimate relationship for a minute. They're asking if they were in a committed intimate relationship for 13 years and then married for 5 years, would there be differences in the division of property related to the CIR piece of it?
Yeah, I'll talk about committed intimate relationships for just a minute. I also, just something so Melissa knows what I'm going to say. We've done like a whole entire webinar on it, like more than once. So go to our YouTube channel and watch it, and you'll know more than you ever wanted to know about committed intimate relationships. Our firm actually handles a lot of committed intimate relationship cases, and we always have over the years. I've handled a lot of them. Some attorneys don't, and they don't know what they are, which they should know because in Washington, this is a real thing. What committed intimate relationships are. Living together with someone in Washington can have very different connotations than other states. If you are in a committed intimate relationship, which is defined as a stable marriage-like relationship, you might be in a situation where community-like property has attached. And what that really means is it really means that while you're living together, if you earned income or had debts or anything, you might be in a situation where your property is up for division. And a lot of people don't understand that at all. So what can you do? The first thing that you can do is figure out how long you lived together continuously. If it was before marriage and it added on to that time, it might expand the window of community property. But things people want to know, how long was that committed intimate relationship? If it was less than 2 years, you're probably not getting anything. 2 years is low end. Was the cohabitation continuous? If you lived together, but you guys moved in and out, that's probably not going to get you anywhere either. What was the purpose of the relationship? Were you actually in an intimate partner-like relationship? If you started out as friends and basically just lived together for a couple of years before you started dating, that's not going to count. But if you were in a relationship the entire time and that tacked on continuously to the marriage, that very well might count. Or if it was a standalone, you don't have to ever get married. That's the whole definition of a committed intimate relationship, a stable marriage-like relationship where the parties aren't married. Did you hold yourself out as a couple? Did people know that you were a couple? If it was some private secret relationship, probably not a committed intimate relationship because that's not very marriage-like. Was it exclusive? Did you pool resources and buy property together? Did you put each other on each other's insurance? There's a lot of different factors to know and to consider in a committed intimate relationship and whether it's going to qualify. Sometimes we'll have a case where the parties might have lived together before they got married, and one person wants to say, oh, well, the committed intimate relationship started the minute that we started living together. That's not necessarily true. Sometimes maybe the relationship wasn't that serious in the beginning, and then maybe some things happened down the line before you got married, and the committed intimate relationship might start partway through. It's a very fact-specific analysis, and I'll say that over and over again about family law because the facts and the details actually really matter. So something for you to think about when it comes down to it. Yeah.
Thank you. Yeah. Yeah, we do have some more questions here.
All right, I'm going to talk about temporary orders and then I'll take those. Okay.
Okay, that's good. Go
I'm
for
trying to
it.
get through, I'm trying to get through some of these basics for you guys. So a lot of people will hear about temporary orders. Do I need those in my case? If you need immediate decisions or decisions soon on child support, child custody, residential parenting plan time, spousal support, spousal maintenance or spousal support are the Washington terms for alimony. So that's that post-divorce support I was just talking about. Who stays in the marital home? Like who's going to live in the house, who's not? Who's going to have control over property temporarily? What car am I going to drive? Who's going to pay the bills? If you can't work those things out with an attorney or amongst yourselves, you need a temporary order. So either party can move for temporary orders and have the court put into place a new normal and a new status quo. Sometimes that is absolutely necessary and helpful. You need to know, how am I going to take care of myself during this time? And if you think about it, like I said earlier, it's a marathon and not a sprint. So you're going to want to have some definite issues. You can also agree on temporary orders. You don't have to have the court decide them. Parties can work them out amongst themselves. So there's a new normal and it's established who's going to pay for the insurance, who's going to get this car or that car, who's going to stay in the home. So it's nice if you can work those things out because it's going to save you time and money. But by the same token, you know, it's very much something that is going to be case specific. So those are the kinds of things that can fall into temporary orders. Oftentimes too, somebody might seek an immediate restraining order for an immediate restraint, and then there might be a temporary orders hearing to follow up on that. So that's another bit about temporary orders. I'm trying to get through just a few basics for you while also answering questions. I do think answering questions is important because it asks questions that everybody else wants to hear too. So I'll take another one.
Yeah, this is a situation that I've heard about a number of times. Similar situations. This person's saying that their 16-year-old doesn't want to go to dad's on minimum time. Do I have to make him? Dad was, a mean drunk and there's a cat he's allergic to there. So he doesn't want to be over there based on a number of his own 16-year-old, opinions. And so what happens in that situation?
I have very definite feelings about these kinds of cases. These are everyone's worst cases. We call them resist refuse cases. A child is resisting or refusing to go. You need to know this, and I'm going to tell you this, and you're not going to like it. You're saying dad's a mean drunk. If dad's a mean drunk to the point that it's dangerous for you to send your kid, I'm going to refer back to what I said earlier. You better go modify your parenting plan because dad could seek to hold you in contempt for not making an effort to send the kids and for not making the visitation happen. And then you could be held in contempt. You could pay fees. You'd have a contempt finding, and your parenting plan could be changed by the other parent. So Washington. There's a case in Washington called Marriage of Rideout. Not that I expect anyone to read it, but you might hear it, especially if you end up in contempt on residential provisions. This happens a lot. When you have teenagers, it's really difficult to force them to go. It's not the same as a 4-year-old you can put in the car and be like, bye. If you have teenagers, they're going to a lot of the time do what they want. But I have had cases, and I have seen cases many, many times where teenagers are refusing to go. And parents might either be involving the kids too much in the discussions about the other parent. Courts hate that, by the way. Don't tell your kid what you think if you think the ex-husband's a mean drunk, or the wife is, crazy or whatever. Don't do it, because that is seen very, very negatively by the court. And a lot of the time you might not be doing it, and the kid might form their own opinions, but the court still might think that you are not supporting the visitation. Marriage of Rideout requires parents to make basically all efforts to make the visitation happen. It goes as far as saying you have to withhold privileges from a child if they will not go with the other parent. So you have to do everything possible. It's not enough to just be like, they don't want to go. That's not enough. You cannot do that. You could be held in contempt for that. I have seen it happen multiple times. You have to make every meaningful effort to encourage and support the visitation, make it happen. And marriage of right out says you even have to take away privileges. If you think there's a safety concern at the house, like I said earlier, then do something about it. Change your parenting plan. Maybe you don't want to have to do that. Totally get it. But just be aware that you have exposure if you are not doing everything possible to make that visitation happen, just like the other parent has to do for you.
Mhm. Mhm. Thanks. I think that's really important. And I know that's really challenging. I worked with
It
quite a few
really
clients in a situation like this where, and they're challenged by their teenager and they feel for their teenager. They probably are in agreement with their teenager's opinions about the situation, but that's, it's really important to understand the legalities of it so that you can protect yourself.
Yeah, absolutely.
Yeah.
Yeah.
Okay. Some other questions. In a marriage where there's no real issues other than a man-child for a husband, can you get more than 50-50 custody? I mean, that's such a good question because I think that what is the default and how do you kind of,
Yeah,
get more
there
than
is no default.
when
Because
there's not really a safety issue or things like
no,
that?
but here's the thing. Where do you live? What's the situation? Because here's the deal. If you feel like, okay, there's no safety issues, I just, want to have more custody, it's more consistent for my kid. The answer is if the dad lives near you, probably not.
Mhm.
If the dad lives far from you or it's not practical, maybe. Here's the thing to think about. When I started doing this over 15 years ago, it was very common for one parent, usually mom, to have every other weekend. I'm sorry, to have all the time and dad to have every other weekend. And then it kind of moved to dad having every other weekend and a midweek visit. Those parenting plans almost never happen anymore. That's like a bare minimum parenting plan. Then it moved more towards maybe dad not having Friday to Sunday, dad having Friday to Monday or Thursday to Monday, or mom. I mean, it could be either parent, right? Or maybe it's two moms or two dads. It doesn't matter. And then it kind of moved to different types of 50-50 plans, week on, week off if the kids are older. If the kids are younger, 2 days, 2 days, 3 days, all kinds of different plans, right? So if there's not a basis for restrictions in your parenting plan and you live close together, essentially all of the research and child development shows that it's a good idea for both parents to have equal time. And that's probably what's going to happen unless there's a really good reason not to. But if you live in Bellevue and dad lives in Tacoma, you're not going to have a 50-50 parenting plan. That's not realistic. So it doesn't matter how good of parents you both are. So you have to think about the logistics. Does it actually make sense? Kids have to go to school somewhere, and they're only going to go to school in one place. They're not going to split schools between two schools. That's not going to happen, right? So how practical is it if one parent's in Everett and the other parent's in Seattle? Are you going to do a 50-50 plan? No, it's not going to work. So, it really depends on also too, how committed is a parent to making it work? How committed are the parents? Like, what is their co-parenting like? If you guys have super high conflict co-parenting, it also might not work. So there's a number of factors, but generally 50-50 plans, if parents live close together and can make it work, are supported. That's just kind of the way it's going to be. So unless there's a basis for restrictions, a distance issue, a conflict issue, things like that. So I hope that
Yeah,
helps.
yeah. And a similar question, somebody's talking about how they agreed to a 50-50, maybe sort of fell forced into it, but that was what was decided.
Mhm.
But they're in a situation now where, they had been a full-time parent and now their 10-year-old is being watched by other people on when it's not their time and, or left alone more than they're comfortable, more than the other parent is comfortable with. What do they do in this situation if they want to try to make a modification? Can you change something that's been finalized?
Good luck. Probably not unless there's a major issue. It's like I talked about earlier. You might not like it that the child could be with you and they're with someone else, but that's typically what's going to happen. There's also first right of refusal provisions where someone has to offer the other parent the time before a babysitter. Highly discourage those. The courts hate them here, and they're just a way for you to keep tabs on the other parent and them to keep tabs on you. So hopefully you don't have that in your plan, unless it's for an overnight. I could see it for an overnight or something with young kids. But here's the deal: changing your parenting plan. Can you change it? I mean, maybe. We do modifications all the time, but we do modifications when it's warranted. And the reason why is that not anyone can change a parenting plan. Why? Well, the policy reasons really behind it are that, parenting plans represent stability and they should be difficult to change. So you have to have a substantial change in circumstances that you couldn't have contemplated at the time that you entered your other plan. And it has to be a change where, it really has to be a change affecting the child. So if you had a 50-50 parenting plan, and relocation is a basis to change a parenting plan, even beyond a modification. But anyway, it is a type of modification. So if you had a 50-50 plan, everybody lived close to each other, and one parent moved super far away, that's a reason to change the parenting plan. If there is detriment in a parent's home where a detriment is a pretty high bar too. Like the child's being abused, the child is like facing serious neglect, or the child's not being taken to school and they're failing. That might be a basis for changing a parenting plan. If a parent's arrested and the kid's in the car, there's a basis for changing a parenting plan. It's a high bar, is what I'm telling you, but it is a substantial change in circumstances that couldn't have been contemplated. You could have contemplated that the parent might not get the child care you would want. That's not going to be a basis to change a parenting plan. 10-year-old left home alone is not going to be a basis to change a parenting plan. But here's the thing to know. The reason why that matters is that you have to have what's called adequate cause, or the court won't allow a parenting plan modification case to continue. First thing that happens is you file for a modification, you say why you're doing it, and then there's a requirement by a certain date that there's a hearing on adequate cause. Is there adequate cause to change this plan? Is there a substantial change in circumstances? If there's not, your case will end then. That's it. So that's why I'm stressing this so much, because it doesn't do me any good to tell you, oh yeah, try to change your plan if you're never going to get past adequate cause. Then you spent a lot of time and money that you shouldn't spend. But we have cases all the time where there is a substantial change and then you need to take action. So evaluating that is important. You might want to talk about the specifics of your situation with an attorney. But if it's just, I don't like the childcare situation, I mean, I get that too. I mean, I totally get that. Doesn't mean it's not valid or that you shouldn't feel that way. It just means it's not going to be adequate cause to change a parenting plan. It's difficult to change a plan. So anybody that's going through the process that's watching this, know that like negotiating your plan, if you're not comfortable going to a 50-50, you might not have to, or you might be able to do a tiered plan based on the age and developmental needs of the child to move up to that, or have some things the other parent needs to do if that's appropriate. So there's a lot of different things that you can do. Do not agree to something that you do not want, because it will be very difficult to change it later. Like that's the best thing I can tell you.
Yeah. Yeah, I can't stress enough how challenging it is to deal with these things when they don't feel fair. Like Michelle said earlier, there is no fair in family court. And I mean, and it is kind of what it is, and it may not feel like what's right or fair to you. But it is the way that it is. And there's a lot of things that you're not going to be able to have control over here. And there's so much really valid emotion around that. So I really just recommend making sure that you have support in trying to kind of find some acceptance around some of these things, because you'll feel a lot better when you do, as challenging as it is.
It can feel very discouraging, but it's important to just have a realistic idea about what you can and can't do.
Yeah.
So hopefully you're getting a little bit of that today. I do want to talk, I'll take a couple more and we're running out of time, but I do want to talk about the life cycle of a case. Typical case. We talked about starting the case. We talked about temporary orders. We talked about discovery. Those are big pieces of the case. Then what? Well, in most cases, in most counties, there's a requirement for dispute resolution. Typically, that's a mediation. Mediation can also be arbitration, but typically it's a mediation where parties have counsel. And this is the an effective mediation. There are lots of different types of mediation. A round table one where you're sitting around a table trying to work it out is not effective. You can't get legal advice in that setting. Emotions are going to flare. It can be very difficult. An effective mediation is what's called a shuttle mediation, where each party is in a room with their counsel and a neutral attorney mediator shuttles back and forth and tries to make a deal. You get advice in private. Even in the most high conflict cases, 9 out of 10 times the case is going to settle in mediation. Sometimes it doesn't. That's why we have trial. That's the next thing. But mediation is very often where cases are settled. So after you've got the temporary orders, you've done the discovery, maybe you have a custody evaluation done, you have financial evaluations done, then you're in the place to go to a mediation and try to settle your case. Or maybe it's able to be settled without mediation, just through negotiation. But very often a real-time mediation is a great way to do it. And then once you've done that requirement, if you still didn't settle, you're going to go to a trial most of the time. And a trial is where a judge will make a decision about your family law case. And judges don't really like family law cases. They don't want to decide where your kids are living. They don't want to decide who keeps what. So if you can settle all or some issues, that's why there is such a focus on mediation and all the work up to preparing for it. So hopefully that gives you some idea about that. I'll take 1 or 2 more because I know we're running out of time.
Yeah, I'm going to try to get through 3 really quick ones.
All right, let's go.
You talked about temporary orders. Is what you achieve in temporary orders usually held in a final order? Is that
No.
okay?
Yeah. It could be. I mean, sometimes it could be. I mean, in some cases, that's persuasive because it's like, oh, well, what's the reason that you now need more money than you were getting in temporary orders? Or what's the reason the parenting plan should be different? Parenting plan might be different, especially if there's a custody evaluation being done while there's temporary orders. You might get a different recommendation. Or you try a temporary parenting plan and it's totally not working, and it's hard on the kids, or it's not working, or somebody's always late for the exchanges. So, not necessarily. It can be a very important precedent that's set in your case, though, because if it is working, it very well could become a final plan, right? So not always. It's not a guarantee at all. Part of the reason it's temporary is because we're trying to figure out what's going on. You also might not have all the financial details when you enter into it, but it can be very persuasive.
Yeah. Does citizenship affect the divorce? If a person has a green card and is a Washington resident, how does that impact things?
Then you're fine. I mean, if you're a green card holder, it's not an issue. I've had cases though where maybe one party's here on an H-1B visa, which is a work visa, and the other party is here on a dependent H-4 visa. If that person is divorced, they will have to go back. So that can be a very big issue, and especially if there are kids involved. But a green card situation is not typically going to require someone to leave the country. So.
Okay. If I choose to represent myself because I can't afford attorney fees at the moment, could I pay for an hour to work with one of your attorneys to help me go over the divorce petition before signing anything?
Yeah, I mean, you could do that. We also, we do this, I think, I don't know, I think other firms do too. If you can do full representation, or if your spouse might be able to help you pay for it, or a friend or family member might be able to help you, that's great. If you can't, sure, that totally happens too. There's also a few different financing options you might be able to look into. But if you just want like some time to go over something with somebody, yeah, you can book a consultation. We also, what I was going to say is we also do consultation packages where you could pay a lower amount for a certain amount of time to consult with somebody that as you represent yourself. I have 5 hours of time. I can come back and ask different things and go through things. So you might be able to do that. It's a less costly way to do it, but it's something that, is better than nothing and can really help you along your way.
Okay, great. And then this person's asking, what will a judge need for a notice of publication to be approved if you don't know the party's address?
That's difficult too. You'll need to show that you made a meaningful, this is like if you can't serve somebody and you're having to serve them by publication. It's better if you have a last known address because then you can serve them there and show that you made, you made a due diligence showing in doing that. If you weren't able to do that, like if you weren't able to get an address at all, you might be going publication. And that, it's going to depend on your circumstances. I encourage you to read the statute. I think it's rule 4. I don't hold me to that, but read the statute and determine what's required. But typically you'll need to make a due diligence showing that you tried to make service beforehand. Service by mail or by electronic means, if you can get that approved, is a lot more cost effective and quicker than service by publication. But if service by publication is your only option, you might want to review the rule and then consult with an attorney if you still have questions, because you can easily do it wrong. So that's just a warning.
Yeah, thank you.
We got through all 3. It was very good.
Yeah,
So
we did pretty good.
I'll let Melissa wrap up, but before I go, I'll just tell you thanks for coming. Thanks for asking your questions today. If you're watching this later, thanks for watching. I would encourage anybody here to check out other videos in our library. There's a lot of information there that's available. You can also find me on TikTok and ask me a question there. I do answer questions on TikTok. You can also schedule a consultation with me or another one of our attorneys. Even if you don't schedule a consultation with us, I would encourage you to schedule a consultation with an attorney. Somebody that does family law, not somebody that does general practice that also does, personal injury and bankruptcy. Go to a real family law attorney because we know the ins and outs. We speak this language. It's what we do. It's what we breathe. Just like whatever you do, that's what you do. So we'd go to you. Like if I have a problem with my taxes, I go to a CPA. If I hurt myself, I go to a doctor. If I, need help with things in my personal life, I go to a therapist. So go to somebody that knows. This is one of the most important decisions that you're going to make in your life about how to move through this process. So anyway, thanks for coming. Hope to see you next time. Also, as a note, you're probably on our mailing list if you got to this, but we also do have a meetup every month. Sometimes it's virtual. Next month will be in person if you want to come and ask questions there. So thanks for being part of our community. Thanks as always to Melissa for being a fabulous host, keeping me on track and going through your questions. I'll see you next time. Take care.
Thanks, everyone. Yes, and I know we did not get to every single question. We had quite a few questions, and so I tried to pull out as many as we could for today. But come again. Thank you so much. Again, feel free to reach out for a consultation with the law firm. If anybody's interested in counseling services, feel free to give me a call or reach out through my website. Yeah, I mean, and like Michelle was saying, if you have really specific questions about your case or about the divorce process, having a consultation with an attorney to really ask all of those is the best way to go. And ultimately, make sure you have enough support in place. Make sure the people around you are supportive and that you have, the right people in line to help support you in this process. It's not easy. Okay, take care, everyone. We'll see you next time. Bye-bye.